A non-citizen convicted of offenses related to alleged drink spiking, who Andrew Giles said he wanted to be rid of, has had a major win in court, with the Commonwealth conceding he can't be deported. On Tuesday, the Federal Circuit Court made declarations that there was no real prospect of removal of businessman Safwat Abdul Hady, currently or in the period of 28th of July 2022 to February 13, 2024, and his detention was not authorized by the Migration Act for those 18 months. So that means that for that 18 months, the state of Australia was detaining this man illegally. They were trampling on his human rights, which the court has now put it to them. The findings opened the way for Abdul Hady to pursue damages for forced imprisonment in that period. You see? So this man have now the right to sue the Australian government for that 18 months they detain him and claim damages for that 18 months because they denied him his freedom and all that, which based on how much he's claiming for his damages, it will now be sent to court for a court to check if how much he's asking for damages is equivalent for them denying him his freedom for that 18 months, or if he even deserves more after any court he sends it to have had the both side of the argument. A judgment will now be passed by the court to determine how much the country Australia will now pay to this businessman, which includes 3 months after the High Court ruled on November 8, 2023 in the NZYQ case that indefinite immigration detention is unlawful. There is no prospect of removal. Abdul Hady is a citizen of Austria, born in the Gaza Strip, who came to Australia in 1997. In 2009, Abdul Hady was convicted of unlawful causing two people to take a stupefying drug, which intend to commit an act of indecency against one of them. The convictions were quashed on appeal. At a rare trial in November 2012, Abdul Hady pleaded guilty to lesser charges of using poison to endanger life or inflict grievous bodily harm. He was sentenced to 2 years and 8 months in prison, but released on the basis of time already. The Daily Telegraph reported that the former Labour Prime Minister Bob Hawke attended Abdul Hady's appeal and had written a character reference saying he had often entertained Abdul Hady at home and found him to always be respectful towards women. So you see, even their former Prime Minister even came to court and wrote a written character reference to say that this man, he has ghosted him quite a number of times, and that this man is always respectful towards women. On 31st of March 2017, the Immigration Minister Peter Dutton cancelled Abdul Hady's visa. He was detained in Villawood from 22 August 2017. Guardian Australia revealed that Immigration Minister Andrew Giles had released Abdul Hady on 13th of February on a bridging visa A. Despite the Home Office Department's submission to Giles warning that if he did not release Abdul Hady when he was likely to be released because of the High Court decision, Giles claimed that Abdul Hady was not part of the NZYQ cohort. Guardian Australia understand that was because the government had believed it could arrange a special character flight to deport him despite his complex medical needs. The judge declared that throughout the period 28 July 2022 to 13th of February 2024, there was no real prospect of removal of the applicant from Australia becoming practicable in the reasonable foreseeable future, which was the test for indefinite migration detention being unlawful stated by the High Court in NZYQ ruling. On that basis, the applicant's detention during that period was not authorized by the relevant two sections of the Migration Act, the judge said. In Abdul Hady's original High Court case, before aspects were remitted to the Federal Circuit Court, he had sought damages for false imprisonment. On 1st of November 2021, Justice Stephen Gagiji said if the plaintiff were to be successful in obtaining a declaration that the whole or some part of his detention has been unauthorized, that part of the matter by which he seeks damages for false imprisonment might well later be remitted to the federal court. So you see, when you read a news like this, you see this man is suing now for 18 months that he has been unlawfully detained in Australia. Rewind it back. In some years to come, this will be the same issue in UK. The same issue in UK if this Rwanda plan continue. You can already see that the 4 migrants that were sent to Rwanda a year ago from the remote island or territory that belong to the UK, you can hear what they are saying. They say that the African country is like an open prison, is unsafe. They have been sexually harassed on many occasions. In fact, they self-imprison themselves because they can't even go out without being harassed in the street. You can equally see that already the Rwanda plan has not fully started. Some people in the UK already are suing that they are being illegally detained. Fast forward to what will happen if this Rwanda plan continues. It is time we tell. Like I always say, at the end of the day, these people always play the champion of democracy to Africa. But African leaders are seeing you detaining your people illegally, seeing you not portraying that champion of democracy you are saying to them or you are preaching to them. That's why when African leader who is acquainted with the news, who knows what is happening in the West here, that you people don't fully respect the so-called human rights you preach to them. That is why when they are doing their own, they pay deaf ears if you are trying to interfere in their issues, because they don't interfere in yours. They say charity begins at home. The highest testimony you can preach to anybody in this life is with your own lifestyle. So before the West will keep on or continue to portray themselves as champions of democracy to Africa, they should act their work in Europe here or in the West here, so that in all ramifications, people will justify with what they see, with what they hear, and what is happening on ground, that truly they are champions of democracy.